All right. Well, thanks everybody for coming tonight. We've asked people to sit away from the camera if they didn't want to be seen. So feel free to take notes. If you want to ask questions, you can interrupt it at any point. If you don't want, if you want to send it up written, that's fine too. So tonight we're here to talk about sexual harassment and the Me Too movement and what that means for your average, everyday, mostly women. It does happen to men too, but we're mostly talking about women here. So let's talk about sexual harassment. I want to talk about the law. What is sexual harassment? And then we're going to talk about the practical realities of reporting. I'm sure that's almost entirely illegible. But let's talk about what sexual harassment is, because we've seen a lot of it in the media. And this is for lack of a better term, a really exciting time for this field because the media spotlight is on it. There's a sense that the tide is really turning on this issue. While certainly sexual harassment laws have been around for a long time, Title VII of the Civil Rights Act of 1964 has been around since 1964, but there seems to be a cultural shift in which women are, again, mostly women, are willing to step forward, are willing to risk the spotlight, and companies are responding. Now, of course, a lot of these involve high-profile political figures, high-profile media figures, and we'll talk a little bit about how that is different than somebody, your rank-and-file manager who's not on CNN every day, and the practical realities of a woman thinking about reporting sexual harassment, what that looks like. But let's talk about what sexual harassment is from a legal standpoint. So sexual harassment, most cases are brought under, again, Title VII of the Civil Rights Act of 1964. And one of the key things about this law is it only applies to employers that have 15 or more employees. So if you were at a smaller employer, you may not be covered at all by that sexual harassment law. And under Title VII, what constitutes sexual harassment is certainly any kind of direct touching. There's also what's called quid pro quo. Essentially, you do this for me, I'll do that for you. And then what is called hostile work environment sexual harassment. And that is generally when there is often that has involved cases where there's no touching, but there's some kind of activity going on that is sexual in nature that essentially changes the workplace. That's what the courts are looking at. And what the courts say is, in order for it to be hostile work environment sexual harassment, it has to be either severe or pervasive, right? Severe obviously could involve some kind of touching. It could involve, somebody exposing themselves to you, somebody forcing you to watch pornography while you're flying with them on a plane. That could rise to the level of severe. Pervasive is conduct that usually is less egregious, but happens more frequently. So perhaps your boss is asking you about your sex life or telling you about his sex life over and over and over. That could rise to the level of pervasive. The difficult thing about severe and pervasive, and this is where a lot of these claims fail, is that courts, it depends on the court, depends on where you are in the country, courts have been very strict on what they consider severe and pervasive. So we've got some really bad opinions out there where courts have said, well, this conduct maybe it was boorish, the manager should have known better, but we're not going to find that it rises to the level of severe and pervasive for the purposes of sexual harassment law. For instance, there was a court case, out of Alabama, actually a female judge that found that a single butt grab did not rise to the level of severe and pervasive. So while it was inappropriate, it was not illegal. So when we're looking at sexual harassment and whether or not it meets a legal definition, we're usually looking at Title VII and we're looking at those factors. Is there some kind of touching? Is it quid pro quo? Is it severe or severe or pervasive? And also for those laws to apply, or for you to have an effective, for you to bring able an effective remedy, it has to be that there is some what they call something happens. You're denied a promotion. You're certainly, if you're fired, if there's some other change in your work environment. For instance, it could be, it doesn't even have to be that you're fired or that your salary is lowered. If your job is changed in some substantial way, for instance, if you're a fairly high-level manager, and this is happening to you, and you are refusing your boss's advances, and all of a sudden all your direct reports are taken away, your job title has changed completely, even though your salary might remain the same, that what a lawyer would call, that's still actionable under Title VII. You could still bring a lawsuit for that. So that's one thing to look at when you're considering these lawsuits. Another factor when we're talking about some of the practical realities, in addition to the 15 employees, is when we're looking at Title VII, you've got to be cognizant of, or you should be, that there's what we call a very limited statute of limitation, and that is the time in which you can bring that case. For sexual harassment cases under Title VII, depending on the state, you have either 180 or 300 days to file with the Equal Employment Opportunity Commission, the EEOC, to file a charge with the EEOC. And if you fail to do that, if you're in, let's say, Virginia and most states in the DMV, that's going to be 300 days. If you fall one day outside of that, it doesn't matter how strong your case is, you cannot bring that. You can't bring that case. You're out of luck. So let's talk about what that means to bring a charge at the EEOC. The EEOC is not a public body in the same way that a court is. So these proceedings are not public. It's the EEOC process is designed such that you don't need a lawyer to do it. It certainly helps, but it's not required. You do something called filing a charge with the EEOC, and you can do that by going down to your local EEOC office. And if you go to eeoc.gov, you can find the location of your area office. It is now possible in most locations now to even file your charge online. This is not a public document. It's not the same as filing a complaint in court. And what that does is it allows the EEOC to investigate your claim. It also, what we call it, stops the statute of limitations. So your claim is safe now if you decide later that you want to bring that in federal court. And I should say, you have to file here under Title VII. You have to file with the EEOC and get what's called a right to sue before you can even file in federal court. So it's not even an option to, even if one were inclined to go file in federal court. Now it is possible in a lot of locations, particularly a lot of cases in the DC metro area, to file with a local administrative agency. So, for example, in the District of Columbia, you've got the Office of the DC Office of Human Rights, where you can also go file a charge with that agency. With these agencies, they do something called cross-file with the EEOC, which essentially means if you go to the DC Office of Human Rights and file, they will also file with the EEOC so that your rights are protected under DC law and under federal law. Which brings up another point in terms of practical reality about these cases, and that is that geography matters, right? And it's a bit arbitrary, but geography matters. Now, why is that? Well, in DC, the DC Human Rights Act applies to all employers, regardless of the size, whether it's one employee or 100 employees. So, if you know, it's also a bit arbitrary, because if you cross the bridge 10 miles and you're in Virginia, there is no comparable Virginia state law. So you have many more limited options in Virginia, even though the same thing may have happened in Virginia that it did in D.C. If you're in D.C., regardless of the size of the employer, you're covered by the D.C. Human Rights Act. It, in many ways, mirrors Title VII, includes a lot of the same rights. There are other differences. You can, under the D.C. Human Rights Act, you can file with the administrative bodies. So with the D.C. Office of Human Rights, you can file with them, or you can go straight to court under this state law, which is different if you were proceeding under Title VII. Another difference with D.C. law is under the D.C. Human Rights Act, you've got 1 year to bring your claim. So in D.C., if you haven't brought your claim within 300 days, you've still got another 65 that you can bring your claim under the D.C. Human Rights Act, and it has a lot of the same remedies. That means that if you were to bring your lawsuit and win it, you can get the same back pay, you can get the emotional distress damages, you can get punitive damages. Not so in Virginia. Maryland also has different state laws that might apply. In some areas, there are local ordinances. So for instance, in Fairfax County, Arlington, Alexandria, they all have their own, they're called some different things, but essentially offices of human rights. There are local county ordinances that can disallow sexual harassment, but the remedies tend to be smaller there. So you don't get usually under Virginia ordinances, you don't get emotional distress, you don't get punitive damages. So those are some of the kind of the legal outlines of sexual harassment cases. Let me talk to you about one more thing about the practical reality of bringing these cases. And that is, should you report? And if you do, what happens? So the first question, should you report sexual harassment if you are in the workplace? We've seen a lot of cases in the news now where women did not report, often for good reason. They felt embarrassed by it. Not that there was good reason they should have been embarrassed, but they felt embarrassed by it. They didn't want it to be public, or they didn't feel like that there was going to be anything done about it. And the truth is, and this is what will be interesting to see, and what I hope changes, one of the changes that I hope we see going forward, is that what I'm about to tell you will no longer be as true. And that is, when women come into our office and ask us if they should report, what we tell them is, first of all, to put yourself in the strongest legal position, the answer is yes, you should report the sexual harassment. And why is that? There are two reasons. So we're going to say, yes, you should, for legal reasons. One is retaliation, protection. The other is it allows you to, and we'll talk some more about this, defeat your employer's affirmative defenses. What does that mean? Well, let's talk about the first one. If you report sexual harassment, let's say you're in a company that you're either in DC, so it doesn't matter the size of the company, or you're in a company that has 15 or more employees. If you report sexual harassment of you or anyone else, and the company retaliates against you in some way, certainly fires you, demotes you, any of the other factors that we talked about earlier, if they do that, that is a completely separate legal claim. And in fact, you can win on that claim even if the court, for whatever reason, finds that you cannot prevail on your sexual harassment claim. So let's say, for instance, that you report your boss has been making a bunch of offhanded comments of a sexual nature around you. And you report this to Human Resources, and shortly thereafter you are fired. And the court says, Well, we don't find that the boss's behavior rises to the level of severe or pervasive. So you don't have a sexual harassment claim. But we do find that you were fired in part because you reported this behavior. Okay? Then that is illegal retaliation. Well, you can't get that protection if you don't report. So if you don't report to your company, then you're denying yourself that kind of claim. The other reason, the legal reason to report, is that there's a case, two cases, Supreme Court cases called Farragher Ellerth. Ellerth is Ellereth, and Farragher is Faragher. And what these Supreme Court cases said, in essence, is that in some instances, an employer, if the harassment is done by a manager, then the employer will be on the hook for his or her behavior, even if upper management didn't know about it. They will be on the hook for that manager's behavior, unless the company basically educates their managers and employees on sexual harassment and sexual harassment law, that's illegal, and gives an opportunity for employees to report it. You'll see a lot of companies have a 1-800 number. You may recall when there were the allegations against Fox, there were some, the cameras were rolling while some of these women called Fox's 1-800 number. A lot of companies have reporting avenues like that. The truth is, many of them are ineffective, but nevertheless, whether they are effective or not is a practical matter. If they exist and you do not take advantage of them, then you may later lose your lawsuit against the company if you try to bring one. So here are the two legal reasons. You get the retaliation protection, and you're going to be able potentially to beat the employer's affirmative defenses if it's your manager that is doing this. Here's one of the practical realities is, and this is what we tell women, that if you are going to report, chances are very good your career is over at that company. That's not to say that some companies don't do the right thing. We have seen that in rare instances where there is a report, the company comes in and investigates and either moves or fires the wrongdoer, and the woman is able to continue her career there. But more often than not, what we see is there is some kind of retaliation, direct retaliation, or essentially your career just sort of stalls out there. So maybe something doesn't happen 3 months from now, but a year from now, it's pretty clear that you're not going to advance any further. So that's a practical reality. And what we'll see, and what I hope happens as a result of this Me Too movement, is that companies, either because they want to do the right thing or they are concerned about the liability, that will become less true. So that if you report within your company, not only are you legally protected, but the company actually is going to do the right thing and take aggressive action. So those are a couple things to think about in terms of the practical realities of reporting your sexual harassment. Now, another thing to consider in cases involving touching, we want to consider criminal and we want to consider So in cases involving touching, not only do you have Title VII, potentially, but you have other laws. The first one is that in many cases, if it's unwanted touching, it's criminal behavior. Unwanted touching of any type can be criminal assault, and certainly touching of certain body parts could be considered sexual assault. So, if your boss is coming and giving you an unwanted massage or butt grabbing or worse, that could be criminal behavior, and you can report that to. You can call 911. A lot of cases, you can walk into a magistrate's office and have a warrant sworn out. If you're in Virginia, in D.C., you could go into any Metropolitan Police Department station and report that behavior, and that could be taken up criminally. Now, you. As someone who is bringing that is not, one thing to consider is that is not your case. So if you bring that, for example, if you bring that in the District of Columbia, for any prosecutor, they've got some constraints on how many cases they can take and whether or not they're going to prosecute that case. So the fact that you report it doesn't mean there's going to be a prosecution. The other thing to remember, particularly in DC and a lot of jurisdictions, if you report it and later start to feel bad or change your mind or don't want this person to be prosecuted, you may not have that luxury because it is now the state's case, it is not yours. So that's one thing to consider. But I think a lot of people don't realize that just a single touching can be criminal behavior, and that can be an avenue for you. Another thing about criminal law is the statutes of limitations are usually much longer. So under Title VII, it's 300 days. Under the DC Human Rights Act, it's a year. Their criminal statutes can be years, sometimes a decade or more, and that's why we see in the Harvey Weinstein case, they are considering bringing some criminal cases because they have much longer statutes of limitation. So that is one possible avenue to get, to shine a light on this and get some justice. The other one to consider for assault and battery is it's both a criminal violation, but there is also these are civil violations. In most states, it is both a criminal penalty and a civil penalty, which means that you can bring a lawsuit for assault and battery. The reason that's important is, well, assault and battery also usually have much longer statutes of limitations, or can. And if you are in a situation, in Virginia, for instance, where there is no, at least commonly used state law that outlaws sexual harassment for a company that's 15 employees or smaller, if what is happening to you is illegal touching, then you would have a claim in Virginia under assault and battery when you might not have a sexual harassment claim. So if there's unwanted touching, unwanted massages, whatever it may be, you may be able to bring a lawsuit under assault and battery in order to get some relief where you would not have one under Title VII. So those are some of the broad outlines of sexual harassment to consider. Now let's think about cases where media attention is a factor. Obviously, the ones that we're seeing on the media now involve high-profile figures where the mere fact that the reports have been made are enough for the company to do something, even though there's been evidence that the company has known for some time that this behavior has been going on. Given the current climate and the fact that these are going to be reported out, if the woman is going to report it and it's going to be on the national news, they don't care what the statute of limitations is because there's PR damage to the company, and so there will be action. We saw Matt Lauer get fired within a matter of, I think it was 24 hours, and he's one of the the most highly paid morning TV personalities in recent memory. So companies are taking this very seriously. In most cases, for most women, I was going to say that media is not a concern. I think that's going to be less true going forward. I think even companies where the allegations involve a man, usually a man, that aren't as high profile are going to be looked at more carefully. But it is true that if you are, work for your average, defense contractor in Northern Virginia, you don't have the same leverage because of PR as somebody who's bringing a claim against Matt Lauer. And that's often, when people come into our office, sometimes they misunderstand or they incorrectly think that the company is going to be sensitive to media when that may not be true. And historically, that has not been true. Companies weren't terribly concerned about sexual harassment claims, at least in terms of media attention. That may be less true going forward. We may see companies really taking a strong look at this. And so some of these legal considerations and which box you fit into and whether you can actually bring a legal claim may be less important to companies, let's hope, going forward because they are either trying to do the right thing or are worried about media attention. One word to folks who might be in management that might be watching this. We know you're not all bad folks. There are many great companies out there doing some really good things. For the legal protections, doing training within your company, which is obviously a good thing to do. For the legal protections, as long as you are providing that training and it's real and you've got some kind of reporting requirement, you will have generally protections under FAIR or LRF. Let me say, as an aside, companies don't always get that just because they offer training and just because they have a reporting requirement. It has to be at least somewhat real. And by somewhat, I mean, like, it can't be that you have that you say you have an ability for people to report sexual harassment, but there's nobody there to pick up the phone. Or if they do pick up the phone, it's not reported up to the chain to management. Or if that management gets it, there's no real investigation done. So a company doesn't get that protection if it isn't in some sense real. And I say in some sense because the evidence suggests, social science research suggests, that a lot of times these training programs are ineffectual. That this kind of top-down approach does not really encourage a culture in which sexual harassment is discouraged, and if it happens, that something's actually done about it. So for management that are trying to do the right things, absolutely, you should have training, and there are many companies out there that will come in and provide this for you. But social science, I think there was an article that came out in a Harvard Business Review just this year about some research that suggested that just the top-down approach is ineffectual, and you should involve your employees and make this a collaborative effort in developing these policies and making it part of your culture. So that's something to consider in trying to eradicate this. So in sum, and if we've got some interesting cases that we've pulled that are going to be provided to folks here, some materials that if anybody's interested in, you can certainly email me at Spiggle Law, and we'll provide those to you. That kind of gives you an outline of what we've talked about here and some sample cases. But let's just review, just briefly, what you should consider. Again, think about the possible claims that you could bring, whether or not you want to actually bring them. I mean, there are very few women that come into our office and say, I'm out for my pound of flesh and I want to bring a lawsuit. What they're looking for is some form of justice for the company to do the right thing. But in order to do that, for many companies, you've got to have some kind of leverage, and your leverage is your possible legal claim, whether or not you in fact end up filing it. And that's another thing to consider before I go back and sum it up, is many of these claims are resolved prior to filing in federal court. So just because you've been sexually harassed does not mean that your next step is running off to federal court and filing an expensive lawsuit that's going to cost you tens of thousands of dollars and result to this public exposure. That's not true for the vast majority of these cases. Many cases are resolved before you even have to file a charge, and by resolved I mean there is some sort of settlement. Many of these cases are resolved at the EEOC, either because the both sides negotiate a settlement or through mediation. The EEOC offers mediation. If you file in DC, in the DC Office of Human Rights, mediation is mandatory, so both sides have to come and sit down in mediation. Many are resolved at that stage. And of course, prior to a lawsuit being filed or it going to actual trial, most cases are resolved. So there's a lot of ways for a woman to get, again, it can be men too. The law does not just, it applies to both sexes, but this obviously happens more to women than to men. For most women, there's at least the opportunity to get some kind of relief other than just going to court. And a great place to find a lawyer is Mawila or Neela. If you're in the DC metro area, it's the Metropolitan Washington Employment Lawyers Association. It's quite a mouthful. Just go to www.mwela.org. It has a great attorney locator function. A national organization is the National Employment Lawyers Association. Mawila is one of the local chapters. Also has a great attorney locator function. It's nationwide, and if you go there, pretty much anybody that's on that list, that's all they do, or mostly what they do is represent employees, and they're going to know their stuff. So it's well worth talking to a lawyer and seeing what your options are, whether or not you choose to pursue those. But again, in summing up, think about see a lawyer, do your research. There are avenues available to you. It's not always saddling up and going off to court, but then think about the laws that might apply to you. Of course, if you see an attorney, they'll talk to you about these. How many employees are at your company? How long ago did this happen? Was there touching involved? Is there a reporting opportunity at your company? These are all important factors that will determine whether or not you have a potential claim and how you pursue it. So I don't think we have any questions here. If we don't, we'll wrap up here. I don't think we have any questions coming in off the web, so we will stop it there. Anything? We got anything off the web? No?
Oh, I have to check.
I want to take one quick look, see if anybody's asking you questions off the web. Otherwise, we will wrap up here, and I appreciate everybody tuning in. I hope this is helpful. We'll keep this up on our website. Oh, I should mention that if you go to my website, if you're on my Facebook page, you'll see it. www.spigglellaw.com. We have a bunch of great information there about sexual harassment. Also, if you go to the EEOC.gov website, they have some really fantastic information about the law on sexual harassment. So thanks for tuning in, and we'll call it a night.